One of the main areas of research our school has been engaged in over the years has been the study of early Irish law. As you may know, Ireland has a very rich and extensive legal tradition dating back to at least the 7th century. 3 years ago, our institute planned the celebration of our 80th anniversary. We thought it would be a good idea to mark it with a series of public lectures on the subject of early Irish law, and felt it would be appropriate to hold one of them at this most important venue here. The librarian of King's Inns, Renata Lee, proved to be a most enthusiastic and efficient collaborator. But when all our plans were in place, COVID descended upon us, so they all had to be put aside for a while. Now, another area that connects our institute with the Honourable Society of the King's Inns is the presence in the library here of a sizable collection of Irish manuscripts. For several years now, these are being digitised by the School of Celtic Studies as part of another project about which you will hear presently. As this process is now nearing its end, we thought it would be appropriate to mark this collaboration and to revive our deferred series of lectures from 3 years ago. So these are the two events that bring us here this evening. Now it gives me great pleasure to introduce our lecturer. My colleague, Professor Fergus Kelly, has a long and distinguished record of research in early Irish law and has many publications to his name. Many of you will be familiar with his Guide to Early Irish Law and his magnificent volume on early Irish farming based on the evidence of the law tracts. He has published editions and translations of several law tracts, including one on the ever topical subject of marriage disputes, and is on an associated area he will talk to us this evening. So may I introduce Fergus Kelly, who is going to talk to us about the status of women in early Irish law. And there is a handout, I think, which everyone should have.
Thank you very much, Rory. Firstly, I must express my gratitude to the King's Inns for hosting today's events and for helping to maintain an awareness among contemporary Irish lawyers of the traditional law of pre-Norman times, often referred to as Brehon law, that is, the law of the brehov, or judge. On this occasion, I will attempt to summarise what we know about the status, rights and obligations of women in early Irish society, as revealed in the Old Irish law texts, mainly dating from between the 7th and 9th centuries AD. Fortunately, a large body of this material has survived and is preserved in the libraries of Trinity College Dublin, the Royal Irish Academy, the Bodleian Library Oxford, and elsewhere. In some cases, we have complete texts. In others, mere fragments. Practically all are printed, though without translation, in D.A. Binchy's 6-volume Corpus Juris Hibernici, number 1 in your handout. In number 2 in your handout, I give the reference to Liam Brannock's companion to the Corpus Juris Hibernici, which describes the content and authorship of the texts. And in number 3, I refer to my Guide to Early Irish Law, which provides a general summary of the subject. In the Early Irish Law series, of which 9 volumes have so far appeared, full translations of the texts are supplied. Number 4. You might wonder at the legitimacy of relying on legal material when generalizing about the nature of a society. Obviously, in any legal code, most attention is devoted to situations where things go wrong: murder, injury, theft, animal trespass, etc. But the Old Irish law texts are somewhat atypical in that they devote a great deal of attention to how things should be in society. And this provides the historian with a wealth of information revealing the underlying ethos of the society. I do not for a moment claim that early Christian Ireland was a woman's paradise. As in medieval European societies generally, a woman was subject to a variety of legal restrictions, some of which must have made life very frustrating indeed. Thus, a woman of the early Christian period in Ireland was normally not allowed to give valid evidence in court. nor was she permitted to act as surety on behalf of another. However, in certain circumstances, a woman may be freed from at least some of these restrictions. The first was by the good fortune of having no brothers and inheriting a substantial land holding. In such a case, she was called a female heir, ban choverbe, number 5, and possessed the normal rights and obligations of a male landowner. There was the difference, however, that she was not able to pass on her inheritance to her sons or husband on her death. The land had to go back to her own wider kin, unless a special arrangement had been made to adopt the sons into their mother's kin. And her husband, if he did not have any land of his own, could even find himself destitute on her death. So, being a female heir was satisfactory enough during the woman's life, but her dependents might be left in a miserable state after her death. Another means whereby a woman could gain legal and social standing independent of husband or other male authority in the early Irish system was by possessing a special skill or attribute. Our sources are frustratingly uninformative about such women, and we must conclude that relatively few women were deemed to fall into this category. A single 7th century law text is our main source of information on this subject. This is a medical law text entitled Bretha Crowliga, Judgments of Blood Lying, edited back in 1938 by Binchy, number 6 in your handout. It lists 12 categories of women who must be nursed at home when illegally injured. Normally, if you injured another person, male or female, in the early Irish system, you were responsible for organising and paying for them to be nursed back to health. Usually, it seems, in a house of a competent relative of your own. So your victim was taken away from his or her own home to be looked after until pronounced cured by a physician. Our law text gives a list of exceptions to this rule. These women are nursed back to health at their own homes, with an equivalent payment made by the culprit to cover medical fees and the cost of nursing care. The identity of some of these women is obvious. Thus, the first woman listed, number 7 on your handout, is the female physician of the kingdom, Ban Liag Tuatha. She's not just a healer with a local reputation, but a professional physician whose prestige extends throughout the territory. She is too important to be allowed to go away on sick maintenance, even in her injured state. In later medieval Ireland, there were specific families devoted to medicine, and many manuscripts survive from their schools, giving us a general idea of Irish medical practice. Next are 2 categories of women with religious affiliations, who are described in metaphorical terms, a stylistic device very much favoured by the authors of the law texts, and indeed in early Irish literature generally. The first is the woman who turns back the streams of war. The Middle Irish glossator, probably working in about the 12th century, is no doubt correct in taking her to be a miracle worker, and gives the example of the Abbess of Kildare. The best-known Abbess of Kildare was St. Bridget, who is traditionally held to be the foundress of this nunnery and honoured as one of the 3 patron saints of Ireland. The other woman of the church mentioned is also a miracle worker. She is one who is abundant in miracles. This phrase is glossed as a virgin or a female hermit, so it seems that she was a recluse, subject to the authority of the church, rather than a nun in a regular religious order. In the next case, the woman accepted from sick maintenance is the Be Rindus, literally the woman who satirizes, metaphorically cuts. which is glossed the female poet or the female satirist. We don't get many references to women poets in our sources, but they clearly existed. Thus, the Annals of Innisfallen record the death in the year 934 of Ulach, daughter of Winachan, who is described as the woman poet of Ireland, Ban Ille Éireann, clearly a poet with a far-reaching reputation. Male or female, a poet's main task was to compose poetry in praise of a patron, usually a king or lord, and to satirize the patron's enemies. The next category is the ban hair, craftswoman, valued most especially in relation to embroidery, but it is of course probable that women were trained in other crafts for which they showed a particular aptitude, especially if there was a family association with the craft. More uncertain is the woman who is revered in the territory. A rather striking phrase, but difficult to know what exactly the author of the law text meant by it. The accompanying gloss is non-committal, merely stating that the territory gives her honour. Clearly, she is too important a figure in the community to be allowed to travel away from home on sick maintenance. And finally, perhaps the most intriguing of all these categories of exceptional women is the Rechtid Gael, literally ruler of a hostage. Female rulers are mentioned in the literature. In an old Irish tale entitled The Voyage of Maelduin's Boat, we are told about the otherworld island ruled over by a beautiful queen with 17 daughters, the widow of a king who died without leaving a male heir. But the annals and genealogies give no historical cases of a female ruler, and the Middle Irish text entitled Ban Chenechas, Tradition About Women, contains numerous references to wives and daughters of kings, but none to an actual ruling queen. Likewise, the Brethra Crowliga glossator can only come up with the example of Queen Maeve, a mythological figure of immensely strong character and an aggressive military leader, but at best only co-ruler with her husband, King Ailill. Their relationship is described in the Táinbó Cúilne, the cattle raid of Cooley. Yet there seems no other way of taking Rechtid than with the meaning ruler. Lawgiver would hardly do, and as far as I can see, the form Gael can only be a genitive singular of Gael, hostage, a term closely associated with the theory and practice of kingship. Our text also lists various categories of women who are clearly excluded for their own protection and that of the host household. Thus, there is no obligation to bring away on sick maintenance a woman who is mentally confused, mar, or violently insane, dásuchtach, number 8. The hosts simply could not be expected to cope, and the unfamiliar environment would also be highly stressful for them. The supernatural always looms large in early Irish literature, with frequent references to fairies, lake monsters, giants, and other creatures of the other world, and the legal material is no exception. It's not surprising, therefore, to find that our text also excludes the female werewolf, Con Éil Conreachta. This woman has been illegally injured and therefore is fully entitled to redress, but because of her propensity to turn into a wolf, she would be an impossible guest in any household. According to a later glossator, she likes to stray in wolf shapes and may consequently indulge in the killing of livestock. Another woman who is excluded because of her behavior is the vagrant woman, Be Fumrive. The glossator credits her with associating with supernatural beings, stating that she goes with the fairies. Another gloss accuses her of summoning demons. A woman, the nature of whose antisocial behaviour is more obvious, is the birach briather, literally the barbed one of words. She is a scold, whose sharp tongue would be unendurable for the carers, and she must therefore be nursed at home. And it's not just the carers the author is thinking of. Like the werewolf and the vagrant woman, there is a probability that she would commit offences while away on sick maintenance, thus bringing on further legal liabilities. Apart from this passage, legal sources concentrate primarily on women's roles in marriage, and this is what I will now turn to. We're fortunate in having two law texts on this topic. The best preserved one is entitled Con Lánamhna, the Law of Couples, and concentrates on the economic implications of divorce. It's edited and translated by Charlene Eska, number 9 on your handout. It starts off with an interesting definition of the 10 categories of sexual relationship, ranging from the formal monogamous marriage down to fleeting encounters under various circumstances, and details the rights and responsibilities of both partners involved. But most of the text deals with the legal implications of divorce and devotes particular attention to the property entitlements of both parties. It's a fine piece of legal drafting, displaying the early Irish lawyers' concern for fairness, and another characteristic of the early Irish legal mind, an almost fanatical love of detail. This manifests itself particularly in this text in the comprehensive discussion of the division of property at a divorce. The goods are divided out in an ingenious manner in accordance with the amount brought into the marriage by each party and by the proportion of the work of the household and farm borne by each party. For example, in a marriage into which both partners have contributed equally, in the event of a divorce, the wife is entitled to 1/6 of any wool still in fleeces, but 1/3 of any wool which has been combed, and half of any woven cloth. The implication is that the husband has borne the brunt of the labour of rearing and shearing the sheep, whereas the wife has been responsible for combing the wool, spinning it into thread, and weaving it into cloth. Similar care is taken in arriving at a just division of the other assets of a marriage, providing us, incidentally, with an important source of information on early Irish social and economic history. The other law text on marriage, called Con Lánamhna Beg, the small Con Lánamhna, sadly survives only in about 40 short Old Irish quotations, probably 7th century, interspersed with Middle Irish commentary from about the 12th century. I give the reference to the transcription in Binchy's corpus, number 10 in your handout, and to my edition and translation in volume 6 of the Early Irish Law series, published in 2014. Another problem is the fact that a substantial section of the text is missing due to a gap in the manuscript. So the text starts off with a passage on the different categories of sexual union, echoing that of the main text. We then have some discussion on the betrothal, Arnazm, number 11 on your handout. Usually, a marriage was arranged by the families of the couple involved. The feelings of the girl herself in the matter would generally have been of little consequence. And the husband too, especially if young, would be expected to go along with the arrangement made by his elders. And Old Irish legal gloss gives 14 as the normal age for a girl to be betrothed to a man or to the church, that is, to become a nun. No specific age is mentioned in relation to the husband, but a reference in the text on status Creath Gavlach states that 20, defined as the age of beard encirclement, was the normal time for adult life to begin, and it's likely that this would have included his marriage if economic circumstances allowed. As well as the standard arranged marriage, there is evidence in the law texts too of marriage for love. One text refers to a marriage where the husband has fraudulently wooed his bride with the assistance of a love potion. If his deceit is revealed, she may divorce him with retention of the bride price. Obviously, in an arranged marriage, no love potion would be necessary. So we must assume that in some circumstances, a girl is entitled to say yes or no to her suitor's proposal. Our text has quite a lot to say about the bride price, or cuivre, paid by the husband or his family, number 12. Conventions regarding the payments associated with the marriage contract vary greatly throughout the world. In the Western world, the dowry, which dominated the courting habits of our forebears, seems virtually extinct, whereas in other parts of the world it remains a crucial issue, with the onus on the bride's father to come up with a large dowry. It's clear that from the early Irish law texts that property might be brought into the marriage by the husband or the wife or both. In general, the husband or his kin paid a bride price to the father of the bride, and there's some evidence in our texts that the payment might be delayed over a number of years, probably up to 3. This system also finds echoes in some parts of the world today. After the discussion on the bride price, we have a gap in the manuscript. When we rejoin the text, the author is in the middle of a discussion on the wife's legal obligations to contribute to the economy of the household. A wife's work, of course, depended very much on her rank in society. It's clear from our sources, law texts, sagas, poetry, etc., that women of the upper classes spent a good deal of their time with their husbands at formal and social occasions. Otherwise, they seem to have been principally engaged at the art of embroidery, drinivecht, number 13, a familiar occupation of high-born women throughout the medieval world. Women of lower rank worked alongside their husbands in the major tasks of the farm, such as ploughing, reaping, and the herding of livestock. But in general, their work was concentrated in or near the house to a much greater degree than the man. So the wife was in charge of the hearth, whereas the collection and splitting of firewood was a male task. The husband had the major role in the sowing of cereals, threshing the heads of corn, and drying the grain in a kiln. But the grinding of the grain in a quern and the kneading of the dough were female tasks. Both wife and husband were legally obliged to carry out their economic obligations within marriage. According to another law text from around the same period, the Heptads, that's number 14 over the page, a husband who fails in this regard can be divorced with forfeiture of the bride price. He's classed in a rather strange phrase as fer critha, literally a man of stone. And the text states simply that it is not right that a child should be on the road. The implication is that he is as unproductive as stone or stony ground and incapable of supporting wife and children who are liable to be reduced to homelessness. The marriage is therefore terminated. Our text concentrates a great deal on the role of the wife in relation to the manufacture of cloth and on her position as supervisor of the kitchen. The first matter dealt with after the gap in the manuscript is that of the wife who does not carry out her obligations as a dressmaker, number 15 in your handout. Because material is missing, we do not have the details of her inadequacies in this area, nor of their legal consequences. However, the accompanying commentary gives us some idea of the type of complaints made against the wife. 3 faults are identified in relation to the manufacture of clothing: not making it, nev dhéanamh, making it badly, droch dhéanamh, and making it late, mal dhéanamh. There's evidence from another passage of legal commentary attached to this text that the making of a garment for her husband was one of the first duties of a young wife on her marriage. To be found wanting in this marital duty was clearly a major failure on her part. The next offence, number 16 in your handout, is also a serious one, as the wife has deliberately allowed the wool to be ruined while spinning it. Evidently, she's been guilty of some sort of destructive tantrum at the spinning wheel. She has thus wasted a valuable resource and so faces heavy penalties. She must restore twice the quantity of wool which she has ruined. The bride price must be returned, and her husband must be paid his full honour price for the insult to his honour by her act of wanton destruction. Indeed, it's hard to see how a marriage could continue after an incident of this nature. In practice, the payment of the husband's honour price and the restoration of the bride price would have come from the bride's own father or kin group. She would not, in the normal way, have access to this kind of wealth. As the original bride price given to the bride's father was an integral part of the marriage contract, its return would have been tantamount to an undoing of the contract. I suspect that a divorce would normally have been the result, though this is not explicitly stated in our text. At all events, it is at least very clear that it's in the financial interest of the bride's own family that incidents of this type did not occur. Other acts by the wife which damaged the domestic economy were also severely penalised, but clearly not to the extent of a divorce. Number 17 in your handout deals with the offence of a wife killing meat for a party of visitors who were not entitled to meat. In early Irish society, there were rigid conventions with regard to the provision of hospitality to visitors. No law-abiding visitor could be turned away. It was something like the code of the Bedouin towards the passing traveller in the desert. But at the same time, there were accepted legal limits to the food entitlements of visitors. These largely depended on their rank and on the season of the visit. If a wife, for whatever reason, had ordered an animal to be killed to provide meat for visitors who were not entitled to this sort of treatment, she was in trouble, even if she had acted purely out of goodwill. One imagines some sort of scenario as a tired husband arriving back after a hard day's work to find that his wife had ordered their best ox to be killed to feed a disreputable group of itinerant musicians. In such a case, we are told that the wife had to restore the value of what she'd taken from the joint economy of the household, as well as refunding half the bride price to her husband. Again, the likelihood is that she will have to draw on the resources of her own father for the purpose, and we can be sure that he will not be pleased. In the next case, number 18, the guilt of the wife is greater. Here, the husband has arranged for the wife to provide food for the workforce. But if she fails to carry out this task, whether through forgetfulness or malice is immaterial, and the workmen go hungry, the retribution is heavy. This failure is, of course, a disgrace to the husband, and so she must pay him his honour price, a substantial sum, even if he is a commoner, and it increases with every step up the social ladder. She must also refund her bride price to her husband and pay each workman compensation for getting no dinner. Somewhat unfairly, it seems, If it is the husband who has forgotten to make the arrangement for the dinner with his wife, the wife is of course exonerated, but no penalty is levied on the husband other than the payment of a fine to the workman for not being fed. Also linked with a wife's duty of providing meals for the household is an unusual offence described in our text as déanarod cun, which appears to mean starving a dog. Number 19 in your handout. It seems that the wife has removed food from her husband's dog out of malice. The dog is very much associated with the man of the house, so a wife who wants to cause distress to her husband might be tempted to target this animal's food supply. If her crime is detected, she must pay a fine of a 2-year-old heifer to her husband. Apart from failures in the domestic obligations of the marriage contract, the other great cause of marital discord relates to sexual matters. Of the 23 offences treated in the surviving portions of our text, 8 are sexual in nature. Legal guilt may be fixed on husband or wife, or may be divided between them. At the less serious end of the scale, our text refers to a willing or consensual kiss which a wife bestows on a man other than her husband, number 20 in your handout. The term used for kiss is the onomatopoeic mem, distinguished in Old Irish from the non-sexual kiss pogue, from Latin pax pacem, peace. This is not grounds for divorce, but nonetheless a legal offence. So the wife must, from her own or her father's resources, pay her husband half his honour price and restore half the bride price. It's worth noting here that Welsh law from about the 13th century takes a more lenient view of such lapses by a married woman. According to Welsh law, if she kisses another man, he must pay a quarter of the fine for sarhaid, or dishonour, to her husband. The text says nothing about any payment to be made by her. Another offence of a sexual nature which has modern relevance is that of the wife who uncovers her head in public, number 21. As we all know, conventions regarding the covering of the human body, particularly that of the adult female, vary enormously in different cultures and periods. Currently, we see a worldwide increase in the wearing of female garments which cover the whole body, including the head and sometimes the face. Conversely, in Western society, there's a general tendency towards a relaxing of conventions regarding the covering of the head in public, even on solemn occasions such as religious services. We don't know very much about early Irish dress, but the limited evidence from texts and illustrations suggests that young girls wore their hair in ringlets, which were uncovered. Such a girl is described in one text as a trilseach ré doga, a ringleted one before choice, that is, before a husband is chosen for her. Perhaps immediately after betrothal, and certainly after the wedding, an Irish girl of the early Christian period would cover her hair with some sort of linen headdress and was expected never to expose it in public again. The commentary, which lays down the legal principles covering the various offences relating to female exposure, is particularly difficult to interpret, but it is at least clear that the author is distinguishing two categories of exposure, that of the face and that of the back of the head. Evidently, the exposure of the back of the head was felt to be less serious than exposing the face. The legal commentary is also concerned as to whether the offence took place at night or during the day. Apparently, nighttime exposure was regarded as more insulting to her husband. The fine for a wife's uncovering her face or the back of the head ranges from half to 1/4 of the bride price. So it's at the lower end of the scale as regards the penalties imposed on a wife. Another matter dealt with in detail in our text, number 22, is much more serious than kissing or inadequate headgear. This is the case where a bride is found not to be a virgin on the wedding night. Her maidenhood has been destroyed. In many societies, ancient and modern, this is of course a catastrophe for a bride and a matter of deep shame for her family. She may even suffer the death penalty. The procedure, as described in our text, seems a lot more sensitive to the rights, let alone the feelings of the suspect bride. A number of different situations are dealt with. Firstly, if the betrother of the bride, usually her father, conceals the fact that she is not a virgin, he must refund the bride price, pay double the mourning gift, the term used in Irish is shekels, as well as the honour price of the cheated bridegroom. Presumably, in such circumstances, the marriage is abandoned and the girl returns home. However, if her father betroths her in all innocence, unaware that she's not a virgin, he is free from liability. The girl, however, forfeits her mourning gift, which is logical in that it is the price of her virginity. The legal commentary here is not altogether clear, but the implication seems to me that the marriage would normally go ahead, even though the bride has concealed the fact that she'd previously slept with another man. The crucial element appears to have been that the marriage contract was made in good faith, with no intention to deceive on the part of the bride's father. The wedding night may also bring other legal problems if the marriage is not consummated. According to Legal Heptad 3, number 23 in your handout, if the non-consummation is due to impotence on the part of the man, the marriage is abandoned and the bride price which she has paid to her father is forfeit. The explanation given in the text is that any impotent man is not easy for a wife. As so often in our sources, the later commentary on this heptad introduces a further consideration. If there's an element of deception on the part of the man, that is, that he was fully aware of the problem and yet went ahead with the marriage, he must pay the bride her honour price along with forfeiture of the bride price. Evidently, it was felt that the circumstance of deliberately entering into a marriage which could never be consummated was felt to be an affront to her honour. But if there was no intention to deceive, the retention of the bride price is all that she is allowed. Our text is particularly thorough in relation to the delicate matter of a wife and husband's obligation to be available for intercourse at appropriate times. And we find what seems an almost obsessive concern that procreation within marriage should be proceeded with to the maximum level possible. So, as you see in number 24, the next offence is that of not waking to have intercourse with her. Nev dhúscail do chovrog fria, which is further explained in commentary as avoidance of the couch. This brief description of the offence hardly refers to a single occasion when a husband is too sleepy or drunk to perform his marital duties, but is much more likely to refer to a pattern of behaviour in which a wife's conjugal rights are habitually flouted. Due to the fragmentary nature of the text, it's not clear exactly how this offence is dealt with, but it seems that a fine equal to the bride price is payable. There's a similar onus in law on the wife to be available for intercourse. Another decidedly odd legal dispute is number 25, the testimony of menstruation on a woman, which I find rather difficult to interpret. The basic situation, however, is clear. The wife says that she is menstruating and therefore unavailable for intercourse. If her husband disputes this claim, recourse must be had to female witnesses to give evidence one way or the other. If it emerges that she's been telling the truth, the husband is guilty of wrongful accusation, dervorgal brega, and must pay a heavy fine that is twice the wife's bride price and her honour price. If, on the other hand, she has been lying, the fine is equally heavy. She must return the bride price and pay her husband his honour price. It does seem to be taking both offences very seriously, and so far as one can tell, these regulations are held to apply throughout the marriage. So apparently, no tired wife can at any stage lie that she is menstruating to escape the attentions of her husband. And any husband who accuses his wife of deceiving him in this matter runs the risk of incurring a very heavy penalty for wrongful accusation. Indeed, one wonders, what is the source of these various legal offences listed in our text dealing with the intimate side of marriage? Are they actual cases which came before a court, or are they included by the author as part of the previously mentioned tradition in the law schools of dealing with every topic as comprehensively as possible? My feeling is that the legal author is reflecting the general ethos of the society with its strong emphasis on human fertility. With high mortality from disease and warfare, and many hands needed on the farm and in the house, every kin group wanted children, lots of them. Other law texts illustrate the same approach with the penalising of anything which came in the way of the fertility of a married couple. Thus, the law text on injury lays down an extra fine called ariadod cumberta, prevention of conception, number 26 in your handout, which is levied on a person who illegally injures one partner in a marriage, thereby causing the victim to be brought away from home for nursing back to health. This is to compensate for the procreation which would have occurred if the injury had not been inflicted. Another text, Legal Heptad 3, number 27, deals harshly with the infertile husband, fer divreta. He can be divorced with forfeiture of the bride price, though we're not told how the couple's infertility is pinned on him. The accompanying commentary states further that if he entered the marriage knowing of his infertility and deliberately misled his bride, he must in addition pay her honour price. But if she knew of his condition beforehand, we are told rather cryptically that the marriage remains valid until hatred comes. And if infertility can be attributed to a wife, according to one text, she suffers a similar fate, divorce and return of the bride price. But it must be said that there seems to be a good deal of legal uncertainty and even inconsistency surrounding the whole difficult area of infertility, male or female. Another legal heptad lists various cases where husband and wife may temporarily separate while remaining in a married state, including seeking offspring if either of them is infertile, number 28. In my Guide to Early Irish Law, because of the great emphasis on fertility in our sources, I wondered whether this meant that the fertile mate of an infertile wife or husband could legally procreate with another partner while leaving the original marriage intact, a form of surrogate parenthood. But other scholars have favoured the explanation that this is a reference to pilgrimage to a shrine or other holy site in the hope that the childlessness might be cured through petitioning a particular saint. And certainly there's no doubt that infertility has always been one of the major reasons for pilgrimage in Ireland and elsewhere. Moving on to number 29 in your handout, suspicion of her shame. We have the case of a wife who is suspected of infidelity by her husband. She can exculpate herself by her own oath alone. But if another person suspects her as well as her husband, she must procure a further oath on her behalf. And that is as much as the text tells us, beyond remarking that if she turns pale or blushes or trembles when the accusation is made against her, that these reactions are not held to be evidence of her guilt on account of the shameful nature of the allegation. This brings us to a legal issue common to all societies of how to deal with adultery by either party in a marriage. This was a particularly complex problem in the early Irish system because of a deeply entrenched ambiguity about monogamy. The ideal marriage, as presented in texts such as the law text on status Creath Gavlach, is one of lifelong monogamy, reflecting the standard teaching of the Church. But the law texts also habitually recognise the position of the secondary wife or adultrach, a term borrowed from Latin adultrix, number 30 in your handout. She does not have the full status of the primary wife or caedventure, but nonetheless has a recognised legal position. Other texts distinguish three levels of wife or concubine. Their status in society is normally dependent on that of the man. The primary wife has half his honour price, a secondary wife a third of his honour price, and lesser concubines 1/4. It's clear that it was quite usual for a man to have simultaneous relationships with two or more women, and the main tract on marriage duly distinguishes less formal arrangements than full marriage, such as the relationship of a man visiting, in which a man comes regularly to the woman in her own home with the knowledge and consent of her kin. Other relationships include that of a woman abducted without her kin's approval, and that of a woman who is visited in secret, again without her kin's approval. How did Irish law attempt to deal with these legal and emotional minefields? Firstly, it's clear that a primary wife had the right to opt out of the marriage if her husband brings in another woman. She can divorce him, and being the injured party, the bride price is not refundable and stays with her. She can take her share of the assets of the marital household and bring them to her father's home. As I've mentioned, Con Law Nufna provides us with a comprehensive and thoughtfully worked out guide to the division of the marital property. But often it must have been the case that leaving the marital home is not an option. Her father may be dead, or unwilling, or unable to take her back. In such circumstances, she just has to tolerate the situation as best she could. The law does, however, provide her with a certain legal protection if she wishes to vent her feelings on her husband's concubine. For a period of up to 3 days after the concubine's arrival, she can inflict non-fatal injury on her rival. But in retaliation, the concubine can only indulge in hair-pulling, scratching, or name-calling. As in the case of adultery by a husband, an extramarital relationship by a wife could also lead to divorce, with surrender of the bride price. And if the wife becomes pregnant by another man, her situation is doubly unpleasant because the child is held to belong to the husband, not to the biological father. So if the biological father wants to rear the child as his own, he has to buy it back from the husband. Indeed, we are grimly told in one text that the husband has the power of life or death over this child. This is in the 13th century summary of Irish law by Gillen and Nave MacEagan, Chief Judge of the province of Connacht. He states explicitly, a child which is conceived with the wife of a married man, it's legal for him, the husband, to kill it if it is not purchased from him. Number 31. To sum up, the edited law texts provide us with a great deal of information about the position of women in early Irish society. Needless to say, the law texts cannot be expected to provide us with a comprehensive picture of what it was like to be an adult female of the period. These texts are not sociological surveys, but responses to legal questions which have arisen or are felt likely to arise. Nonetheless, we can assume that they reflect, to some extent, the general practice of the society. For example, if in actual fact it was impossible for a woman to improve her legal standing through professional achievement, then there would be nothing about it in the law texts. There would be no point bothering. But there is, so we are entitled to conclude that such a situation was not all that uncommon. On the positive side, I would point to the serious and consistent concern for a woman's honour, with heavy penalties being imposed in the event of insulting or scurrilous comments by a husband about his wife. Thus, Legal Heptad 3, number 32, on your handout, allows a divorce to a wife whose husband blabs in public about the intimate side of their marital relations, because, in the words of the text, it is not right for a man who tells of bed to be under blankets. She may likewise divorce him if he circulates a false story or satire about her, so that she becomes a laughingstock. She's provided with legal protection against marital violence to the extent that any blow inflicted by her husband which leaves a bruise or draws blood is grounds for divorce. In addition, our text deals with the problem of a wife being subjected to violence by her in-laws. And on the economic side, we find serious thought being devoted to the rights of a woman within marriage, endeavouring in particular to ensure that a feckless or rapacious husband is not in a position to squander the joint marital property. Thank you very much.
And finally, briefly return to the manuscript collection at the King's Inns. In 1999, the Dublin Institute for Advanced Studies embarked on a project called Irish Script on Screen, or known in brief as ISIS, with the aim of digitising all Irish manuscripts and making them available to all online. Our manuscripts, Irish manuscripts, and mainly in Irish but also in Latin, and there are in excess of 5,000 of them, are found in institutions in Ireland and elsewhere. Each one has its story to tell. Was it brought to its foreign destination by an Irish cleric in the 8th century, or maybe in the 19th century by people fleeing after the famine and who brought a memory of their homeland with them to the New World. The King's Inns collection is particularly valuable. Dating from the 7th century, the Irish manuscripts in general are a testament to this country's engagement with religions, science, medicine, law, genealogy, history, and many other areas of intellectual and imaginative endeavour. Often unique in their contents, they are a valuable part of our own and indeed of Europe's heritage and are quite priceless. Through ISIS, they're being made available online for all and can be viewed worldwide. This is an ongoing process in which we're involved, and I'll hand you over now to my colleague, Anne-Marie O'Brien, who will explain ISIS to you. Anne-Marie.
Good evening. We wanted to mark the Irish Script on Screen collaboration with King's Inns this evening, a partnership that has spanned the last 10 years. But first, for those of you who are unfamiliar with the Irish Script on Screen project, or ISIS as it's commonly known, it is a project that was launched in 1999 by the School of Celtic Studies in the Dublin Institute for Advanced Studies. It was one of the first specialist manuscript digitisation projects established in Ireland, and to date it is one of the longest running in Europe. Through ISOS, Irish manuscripts have been given a new platform for discovery, not only for academic research purposes, but also to be viewed and enjoyed by the wider public in general. There is roughly 5,000 survived Gaelic manuscripts that we currently know of. They can be found throughout the world in libraries and private collections, mainly located in Ireland, Scotland, England, and Wales. Currently, we have 28 different institutions from Ireland and abroad collaborating with the project. There is 450 manuscripts on the Irish Script on Screen. This equates to upwards of 80,000 large resolution images. The study of these manuscripts provides us with a unique Irish perspective and how we perceive ourselves, our neighbours, our way of life and position within world society. The manuscripts that survive today are a reminder of our thirst for learning and our unique repositories of the knowledge accumulated at the time. To give you an idea of some of the diversity of manuscripts we have in ISOS, I've selected a few. Here is a 14th century legal manuscript, the Seanachas Mór, MS 1316 from Trinity College. It is bound in 5 volumes and contains Breton laws, as well as miscellaneous religious, medical and poetic material, reflecting the broader interests and general education of medieval Irish lawyers. Early Irish law, also called Breton law, comprises the statutes which govern everyday life in early medieval Ireland. Here you can see the early Irish laws of beekeeping. The honeybee was very important in the early Irish economy, as demonstrated by the special law text. The honeybee was of particular importance in Gaelic society, as it was used to produce beeswax for candle making, wax tablets, seals and adhesives. Here we have the Yellow Book of Lecan, TCD's MS 1318. It is a composite manuscript dating from the late 14th, early 15th century. It consists of 16 manuscripts which were all bound together. It contains medical tracts, grammatical material and prose tales, including almost the whole of the Ulster cycle. Shown here is a beautiful diagram of the seating plan of the banqueting hall at Tara. The section of prose gives a description of the diagram of the banqueting hall, making specific reference to the fact that there are 12 couches along each side of the outer section of the hall. There are 8 distributors, cupbearers and stewards at the back of the hall. When one enters the hall through the Duras, the entrance, depicted in the diagram as facing the lower margin and highlighted by the use of red ink, one is met by the king's doorkeepers to the left and fools to the right. Irish Script on Screen has a large selection of medical manuscripts. Almost 100 medieval manuscripts survive that contain medical text in Irish. The largest collection of these manuscripts is held in the Royal Irish Academy. They consist mainly of translations or adaptations of continental Latin treatises into early modern Irish. Here we see a leaf from one of the best known of them, the so-called Book of the O'Lees, which written about 1450, probably in County Offaly, by the scribe named Conall Balloch MacPartlin. The text comprises an Irish translation of an Arabic medical text titled Table of Diseases. It comprises 44 tables divided into 99 compartments, setting out in chart form the principal diseases affecting the various organs of the body, and supplying brief treatments for each, showing name, prognosis, stage, symptoms, cures, etc. of the disease in question. Modern physicians and patients are well used to information being presented in tabular form. But in the 1100s, this type of chart presentation was considered a major innovation in medical teaching. The learning in these books is typical international and outward-looking, setting the tenets of medical knowledge as understood at the time. We have snuck in a couple of Latin manuscripts too. Here's the Cathaireacht of St. Columba, Cathaireacht meaning the buckler, a late 6th century Ulster psalter from the Royal Irish Academy. The manuscript is the oldest surviving manuscript in Ireland, containing some of the earliest examples of Irish writing. The digitisation of this ancient medieval manuscript commemorated 1500 years since the birth of Columcille. Born in Donegal and patron of Derry, a key figure in the early medieval Christian church. He was a figure greatly revered, particularly in his native Ireland. He spent most of his missionary life, but also throughout continental Europe. It became known as the battler from the O'Donnell practice of carrying it thrice right-hand-wise around the field of battle as a talisman. The beginning of each new palm is indicated by an ornamental capital. The framework of the capital is often outlined by a series of scarleted dots, and the decoration consists mostly of spirals and animal heads. this beautifully neat spiral initial MS were made using a compass. Take a closer look, you will see two little dots above the middle spiral pricked into the vellum. Last November at the School of Celtic Studies, Chernow, we were delighted to be able to launch our new redesigned website, which brought the benefits of IIIF. Here you can see our new landing page. The idea was to make this space more visually engaging to both the academic user, the casual browser, and for members of the public who might be interested in finding out more about manuscripts in general. We have added an exhibition area to allow the public to engage with manuscripts in a way they might not have had the chance to in the past. Here you can see our collections, which includes the likes of the National Library of Ireland, the Royal Irish Academy, Trinity College Dublin, and also international collaborations with the likes of the National Library of Scotland, State Library of Victoria, the British Library, and of course the excellent King's Inns Library. The King's Inns page begins with the introduction to the library itself and information on their manuscript collection. The full collection of 29 Irish manuscripts have been digitised and span from the 15th to the 19th century. Each of the manuscripts are laid out in visual cards that can be easily selected, and by hovering over the image, a handy snippet of information is displayed pertaining to each of the manuscripts. The King's Inns manuscripts range from copies of Keating's History of Ireland, historical poems, genealogies, oceanic tales, religious matter, classical adaptations, medical grammar, a few Irish dictionaries, something for everyone. MS1 and 2 are copies of Geoffrey Keating's Force Feaser Éireann, which became one of the most influential histories of Ireland ever written. Here you can see our new Mardor 3 viewer, and under the viewer you'll find all the catalogue descriptions from Pork de Bruin's Catalogue of Irish Manuscripts and King's Inns Library, Dublin, published in 1972 by the Dublin Institute for Advanced Studies. Keating wrote in Irish prose. He placed particular emphasis on the value of the Irish language as a repository of knowledge about the Irish past. As a Catholic priest, he also regarded Catholicism as one of the defining characteristics of the Irish people. His history popularised a particular combination of myth, religion, and history that became widely accepted from the 17th to the 20th century as part of a cultural definition of Irishness. Here I am demonstrating the viewer. You can click back and forth through images with these using the toggle buttons below. There is also a zoom button to carry out a deep zoom. Another example of what you can do with IIIF is to work with a number of manuscripts at the same time, whether from the ISIS collection or other institutions that have also adapted to IIIF. By using the manifest button, I can drag and drop my select manuscript to populate a list of manuscripts to work from. Here is King's Inns MS15, a 16th century vellum medical manuscript. Formerly bound in oak, now only half of the front cover survives. It was split and mended with wire, which is attached to the manuscript by 3 heavy tongs. Next, we have a lovely example of illuminated capitals. One of the key features in the success of ISOS is the high quality attained in the image capture itself. Images are digitized at a resolution of at least 600 dpi, which each pixel being 24-bit color, so you can really get a good, clear detail when zooming in. Next, you can see a blank space on the page with a small letter "or," which has been left as a guide for the illuminator who would do the artistic work of filling in the decorative initials, just in case he might be in doubt. The little guide letter would hint to him the letter to be supplied. On this folio, you can see, or rather try to see, the ornate initials in dry point. By using our new tools, you can now manipulate the image. You can change the brightness, the contrast, saturation, grayscale, and invert the colors. This can be particularly useful when dealing with discoloration, as seen here on the last folio, which has been badly stained due to being exposed to the elements, showing that missing leaves at the end of the manuscript have been lost for a long time. With these tools, hopefully we can now render more of the hidden text that would not be possible with the original manuscript. Again, by adjusting the hue and saturation of the image, you gain the opportunity to physically change the makeup of the page and hopefully gain more clarity. Next, we have MS-19. It is an 18th century book of work of the lives of saints bound in a homemade cover of cardboard and leather, known as Scholar's Binding. It is one of the longest manuscripts in the collection, with over 1,100 images required to display it on screen. Saints, saints, and more saints in this one, including the lives of Columcille, Bridget, Finbar, Declan, and Kiernan of Seagar. Here you can see the back cover in its very individualistic style. Scholars' bindings were homemade by the scribe who do his best in trying to cover the manuscript without the skills of a bookbinder. Next, we have MS-24, an 18th century Irish grammar. This is a brief introduction to the Irish language in 14 chapters. You can also download images free of charge from the Irish Script on Screen website. We offer this in different sizes of download, depending on what your needs are. With the help of IIIF, you can now also work with the number of manuscripts opened at the same time and personalize your workspace, allowing paleographers attempting to identify different scribal hands an opportunity to examine letter forms in detail and to make comparisons with other manuscripts. Through ISOS, Irish manuscripts have been given a new platform of discovery, not only for academic research purposes, but also to the wider public in general. Images have been used for exhibitions both internationally and nationally, displayed in heritage and visitor centres, and for people simply searching for their ancestry through genealogies. Irish manuscripts have had the unfortunate history of being separated and dispersed over the centuries, whether from war or religious persecution. With the ISIS project, it allows us to access to collections that may have been previously hidden in the past and to strive to unite them for the first time together again, virtually with other related manuscripts in the one place. The digitization of manuscripts is a very slow and delicate process, taking weeks for each manuscript to be accessed and digitized. This would not be possible without the generous support of the libraries and institutions that collaborate with the ISIS project, such as King's Inns Library and the dedicated people that work in them. I'd like to give a special mention and thanks to Anata Ní-Hugin, who went with me at every request, even through the tough COVID lockdowns, and helped to bring King's Inn's Gaelic manuscripts to the forefront and now accessible to everyone. But we still have a lot of work to do. We're in the fortunate position to have 450 manuscripts on the ISOS database, but with 5,000 Gaelic manuscripts in existence, there's quite a bit to go yet. Resources and funding are always been sought to further increase the digitisation of Gaelic manuscripts. ISOS provides a powerful tool to progress the study of Irish paleography, to further manuscript studies, and open the exploration of Celtic culture to many future generations to come. Thank you for listening.